Good morning, everyone. How are you doing? Well, there's nothing better than learning about immigration on Monday morning. So my name is Chai Sankumani, and I'm a private attorney here in Nashville, and this is Dawn Gerhardt. She and I practice together at CINA of Nashville, PC, so we've been practicing for about 10 years. And what we wanted to do is kind of give you a basic of immigration. You're not going to be able to go and do complex immigration cases based on this PowerPoint, but hopefully you'll be able to recognize some of the terms, some of the concepts that really involve other areas of law, such as family law, criminal matters. You may see some of these issues pop up. So we'll get started. So before we really get into the nitty-gritty, we want to do a little quiz. Who is a U.S. citizen? So Ryan Gosling is a famous movie star. Does anybody want to guess whether he is a U.S. citizen or not? Okay. He is not a U.S. citizen. He is from Canada, Ontario. We actually have a lot of people in the music industry and the movie industry from Canada. So next up is Marc Anthony. He is a U.S. citizen born. He is a U.S. citizen born and raised in New York. There was some controversy in 2013 because he sang God Bless America at one of the All-Star games, and the internet, being the vast place of comments, had some very unkind things to say about him not being an American, singing a very patriotic song. Natalie Portman. So she is a dual citizen. She was born in Israel, so she has dual citizenship with Israel and the United States. So that means she has all the rights of a U.S. citizen, and she cannot be deported from the U.S. Keanu Reeves. He actually has lots of citizenships. He was born in Lebanon, which I had no idea. His father was American-born, so that means father has conferred U.S. citizenship status onto Keanu. And then he also naturalized as a Canadian citizen. Okay, the reason why we went through that exercise is the Immigration and Naturalization Act pretty much covers non-citizens. So under the eyes of immigration law, there's two types of individuals, citizens and non-citizens. And non-citizens are covered under the Naturalization Immigration Act. So a U.S. citizen cannot be excluded or deported. They cannot be removed from the United States. And all persons who are not U.S. citizens are non-citizens. So if you're a non-citizen, you can be refused admission into the U.S., you can be deported, and these include the legal permanent residents who are the green card holders, those who have entered the U.S. temporarily, such as the visitors, business visitors, tourist visitors, those who are just here to work for their employer. Also includes students as well. And persons who are here by administrative grace, those are the asylees and the refugees, and persons in the U.S. without authorization. So anyone who is not a U.S. citizen can be deported from the U.S. So, and the reason why that is important, some people have grown up thinking that they're a U.S. citizen, and then when they come into the magnifying glass of ICE, they may discover that they are not a U.S. citizen, and they may have grown up and lived here for 30 years, and all of a sudden now they're getting deported. So that's why sometimes knowing your citizenship status matters. And how does one acquire citizenship status? In the U.S., if you were born on U.S. soil, whether the territories or possessions or within the states of the United States, you are automatically a U.S. citizen. So if parents are here on a temporary work visa, and then the parents had a child who was born in the U.S., that child is a U.S. citizen and could possibly become a dual citizen of the other country as well. Now, the other way is by naturalization. Naturalization is the process of becoming a U.S. citizen. So there are certain requirements. You have to take the civics test, the English test. You've had to either have been a legal permanent resident for 3 or 5 years, and then you have to show good moral character. So if you have possibly a DUI or some other criminal matters, that may bar you from becoming a citizen temporarily or even permanently. You can also get citizenship by statute. So if you have either parents who are U.S. citizens, depending on whether the parents are married when you were born, you can maybe be a U.S. citizen by statute. And also if you are under the age of 18 and your parents naturalize, you automatically become a citizen based on their naturalization.
Chai?
Yes.
I just want to interject and say that this is going to be important for those of you who are doing pro bono cases like landlord-tenant or your family law cases. If you have a blended family of non-citizens and citizens, you might want to be looking into the parentage of the kids, because if you have a kid that was born in Mexico or in Canada or somewhere else, they might actually be a dual citizen. They might actually, and they just have to apply for a certificate of citizenship. So a lot of people don't know whether or not they're U.S. citizens or not. So just be aware that if you have a child who doesn't have citizenship, you're going to want to look into the parentage, and for the parent for that matter, right? You could have a U.S. citizen married to a non-citizen, but that non-citizen has parents that were U.S. citizens. Well, that spouse might actually be a U.S. citizen. So you just don't want to overlook the immigration issues that you might face in other contexts.
And immigration will definitely come to play with low-income families. A lot of the government public benefits have requirements that they have to be a qualified alien. So what does a qualified alien mean? There's a whole long definition of who a qualified alien is, and there's also the 5-year bar to public benefits. So these things do matter when dealing with public benefits. Landlord-tenant issues in terms of Section 8 and public housing, and also access to food stamps and teen care as well. So Tony Blair said a simple way to take the measure of a country is to look at how many you want in and how many you want out. As of right now, I think we're on pretty good standing. A lot of people want in rather than wanting out. And so I just wanted to kind of give you a sense of what the numbers look like. Okay. So 314,159,265. That number is significant. That was the U.S. population in 2012, and the significance of that number for all you math buffs is that it is pi times 100 million. So right now, it is about 320 million. But if you ever have a chance to go to the U.S. Census Bureau, they have a breakdown of the numbers, and they also show the population of China and India. And I was shocked to kind of see the numbers together. The U.S. population is only 1/3 of China and 1/3 of India. And then just to kind of see the difference, and there is a net gain of a person every 15 minutes, sorry. So our population keeps increasing, and, well, the world population keeps increasing. So if you ever have time, go to the Census Bureau and check that out. It's kind of fascinating. But just remember this number right here, because when you look at the migration numbers, it is about 1/3 as of now of the population. So from the very beginning, this is the Statue of Liberty, and Ellis Island is the square island over there. But Ellis Island was kind of the processing place in about the late 1800s, early 1900s. the U.S. had the largest wave of immigration coming in. Started by the Irish potato famine, the Industrial Revolution. So there was a large wave of immigrants coming in. So about a quarter of the U.S. population can trace their ancestry through Ellis Island. At that time, 70% of immigrants came through Ellis Island. So now Ellis Island no longer processes immigrants, but it serves as almost a museum, a historical content. And people can go there and trace their ancestry. So here are the migration numbers. So as you can see in the 1905, which was kind of the tail end of the large wave, there was a little over 1 million legal permanent residents. In 2003, the numbers dipped, but as you can see, the non-immigrant admissions, those are those who are coming in not necessarily to live in the U.S., but to either visit, to work temporarily, to come in as students. That is about 1/3 of the U.S. population. And it went down a little bit in 2011, and then the legal permanent resident numbers kind of bumped up a little bit as well. So historically, the United States has been a nation of immigrants, and what has happened in the past is that once a group settles down and gets acclimated and gets affluent, another group will come over to take advantage of the bounty of the United States. And what happens is the group that has settled down tends to draw up the bridge. And this is a little cartoon from the late 1800s. The caption reads, "They would close to the newcomer the bridge that carried their fathers over." So all the rhetoric that we hear today about immigrants, if you go back and read the newspapers in the 1800s, late 1800s, same type of rhetoric, same words. The immigrants are poverty-stricken. They're going to bring diseases. They're going to affect our economy. So just same words, but different ethnic group. So what happened with the immigration laws is that it kind of developed into excluding undesirables. And that included those who were likely to be a public charge, those of certain ethnic origins, from certain countries, those who carry certain diseases, the feeble-minded, anarchists. There was the Chinese Exclusion Act. And all this was codified into what's called grounds of inadmissibility. And in the code today, there are about 20 grounds of inadmissibility. And they basically say, well, if you have these things, you're not going to be allowed into the U.S. You're not going to be allowed to get a green card. There are waivers for some of these, but some of them do not. So these include health conditions. HIV used to be a ground of inadmissibility for a time. That was taken away pretty recently. Criminal reasons are grounds of inadmissibility. So that's why the criminal aspect of immigration law is so complicated, because of the grounds of inadmissibility. And then there's national security reasons, foreign policy, the public charge. That can be an issue with a lot of low-income clients. If they have if they have gotten food stamps or gotten TennCare, a lot of times they'll ask, my children have gotten these. Should I be concerned? Will that forbid me from becoming a legal permanent resident? And the rules are quite complicated with that. Here is some more of the grounds of inadmissibility. The ones that we see a lot that are very unforgiving is the unlawfully present for more than 1 year or ordered removed, and they are barred from coming into the country for another 10 years. And that will matter when we talk about the two-step process of getting a green card. Okay. So here's another cartoon from the late 1800s. Everybody's welcome unless you have these things. So immigration law, one of the reasons why it's so complicated is that the laws come from all the three branches of government, and also so we have a variety of laws. The first and foremost is the U.S. Constitution to establish a uniform rule of naturalization. That's where the federal government gets their power to regulate immigration. And then the three branches of government each have a hand in creating immigration law. The legislative branch passed the Immigration and Naturalization Act. Throughout the years, they'll pass amendments to that. The judicial branch decides the cases that interpret the law. And then the executive branch, generally we work more with, most of the laws that we deal with come from the executive branch, mostly with regulations, the Board of Immigration Appeal decisions, which are the administrative court cases that rule, and then agency policies and guidance. So the executive branch isn't very fast about issuing regulations, and sometimes Congress will pass a law in 2000, the U visa, for instance. Congress passed a law to create the U visa, and the executive branch did not write the regulations for 7 years. So in those 7 years, even though there was this visa called a U visa, there was no mechanism to apply for it because the executive branch didn't write the regulations. And so they had to kind of do a patchwork process. And then when the regulations were finally written, there was a huge backlog of bringing in the ones that had applied for this interim process. So it can be quite frustrating at times. But then there are also the executive orders and executive actions that serve as policy guidance for us as well. Okay. So another reason why immigration can be so complicated is that there are so many players involved. Most of the players are going to be under the executive branch. So we've got the Department of Homeland Security, which was created after September 11th, 2000. The INS, which was under the Department of Homeland Security, was broken up, and then the Department of Homeland Security was created, and under the Homeland Department, DHS, you have USCIS, which is U.S. Citizenship Immigration Service. The USCIS is the agency that grants the benefits of immigration. So if you wanted to sponsor your family member, you would apply to USCIS. If you wanted to apply for your green card, that's where you would go. ICE is Immigration Custom Enforcement. They are the immigration police. They are the ones that enforce the laws within the borders of the United States. CBP also enforces the law, but they do it within 100 miles within the borders of the U.S. So the next agency is Department of Justice, which houses the immigration courts, which is EOIR, Executive Office of Immigration Review, and then that includes the Board of Immigration Appeals. So all the cases that get appealed from immigration court goes up to the BIA, and if you lose there, you can appeal directly to the circuit court, the U.S. Circuit Court. Now, OIL is another part that litigates the cases once it goes to the circuit courts. The other agency is Department of State, and Department of State issues the visas outside of the country. So if you have a spouse who is outside of the country and wants to get a visa, they have to apply with Department of State, and that includes the U.S. embassies, the consulate, and also if you deal with business immigration, you have to deal with Department of Labor. Now, what makes it so complicated is you may have a client who has issues, who has family members who are outside the country that has to apply for a visa with the Department of State, but yet USCIS has to make certain decisions on the waivers. And, there are times when the agencies argue who has jurisdiction. No, Department of State has jurisdiction. You need to go apply there. No, you need to go apply at USCIS. So you're kind of stuck in limbo, where does jurisdiction vest? And sometimes in immigration court, you have to figure out, okay, does immigration court have jurisdiction over my client, or does USCIS have jurisdiction? And it all depends on the statute. Sometimes the statute will say sole jurisdiction will vest with USCIS, and it can get pretty complicated in that way. Like I said, if you want to appeal from the BIA, it goes straight to the Court of Appeals in your circuit. There are certain cases that you can appeal to the U.S. District Court, but Congress has stripped a lot of judicial review off of discretionary forms of relief, so oftentimes we have to go to the Court of Appeals and argue abuse of discretion or, I forgot what the other, erroneous error. Okay. So, immigration has a lot of terms and definitions, and just to give you, I'm going to list these all out since this is kind of sticking. Okay, we've talked about who is a non-citizen. So anyone who is not a U.S. citizen is a non-citizen. We talked about who is a U.S. citizen. Now, an immigrant, under the immigration statute, it divides aliens, non-citizens, into two categories, immigrants and non-immigrants. And immigrants are the green card holders. They are the ones who have the most stable form of status. They're authorized to live and work here indefinitely. They can't vote. There are certain jobs that they can't apply for because it requires being a U.S. citizen. But they can hold that status indefinitely. The problem is that they can still be deported. If they've committed a deportable crime, they can be put in removal proceedings and be deported. And Dawn actually has a client who has been living in the U.S. for 50 years?
Since the 60s.
Since the 60s, and she is now in deportation proceedings because she never naturalized. So non-immigrants are those who are here with a temporary visa. They're either here to visit, which they call people call the Disneyland visa. They are here maybe to work. They are here to be students, but it doesn't confer legal permanent resident status. There are some visas that you can convert into a green card eventually if you meet all the requirements. But for the most part, most of the people who come into the U.S. who are not citizens are going to be non-immigrants. Legal permanent residents are basically the same thing as an immigrant. Now, undocumented. There are two types of categories for undocumented. The first one is someone who has entered the U.S. without papers. They've entered without inspection, or they've entered illegally. They are always subject to deportation because they have never had permission to be in the U.S. And another category of undocumented are those who have come in on a visa, a tourist visa or a temporary visa, and they have overstayed that status or they violated that status. For instance, a tourist who has come in and had a 6-month visa, but they've continued to stay, they are now undocumented because their permission to stay in the U.S. has expired. And the difference between those who have entered illegally and those who have entered legally may matter in terms of what kind of relief they can apply for. Those who have been inspected can often apply to adjust their status to become a green card holder, whereas those who've been undocumented have a lot of barriers that they have to jump over and may not be able to. A visa is a document that is issued by the U.S. government giving permission for that individual to land at a port of entry. It doesn't necessarily allow the person to come into the U.S. That person will land at an airport and they will then be inspected to see if they have any grounds of inadmissibility that prevent them from being released into the U.S. So it's possible that you can get a visa, land at an airport, and then be turned back to your country because you have a ground of inadmissibility. Removal is deportation. They Congress changed the terminology a little bit, so I think people still use the term deportation, but formally it is removal. Removal proceedings is basically the hearing that people get to determine whether they are deportable or whether they have forms of relief that allow them to stay. Oops. It's kind of stuck.
All right, I'm Dawn Gerhardt, and I've been practicing for 10 years, and if anybody had told me that I was going to practice immigration law, I would have said, no way. There's no way. Who on earth wants to do that? That sounds terrible. And in fact, when I was in law school, I went to the University of Nebraska, and so we're in the 8th Circuit there, and I worked at the clinic, and I did pro bono, and I had to write half of an 8th Circuit Court of Appeals brief on immigration. And I remember taking home the case, one of the main cases that had just come out of the Supreme Court, and I went home and sat on my couch and I read it, and I laughed through the whole thing because I didn't understand a paragraph of it. I had no idea what they were talking about. It was incredibly complicated, and even after I finished the brief, I felt like I walked away not really knowing what on earth I had written. And so anyway, when someone asked me at school, what do you want to do? Immigration was definitely not what I wanted to do. So anyway, but here I am practicing immigration law 10 years later. So what happened? Well, as it turned out, I came back to Tennessee and I worked with a sole practitioner who all he did was immigration. And those of you who have a heart, who have ever want to practice human rights law, right? You have a passion. You want to make a difference in the world. Immigration is a place you can do that. Here, all of a sudden, I'm working with clients who have suffered the 1994 genocide in Rwanda, and they're sitting across from my desk as they laid amongst dead bodies and had the birds picking at their skin while they hid from the Hutu, you know. And all of a sudden, I'm filing for asylum for these people, and I'm fighting for them for the right to stay here because they're unwilling or afraid to return home. All of a sudden, I'm working with victims of human trafficking. You know, I have people who have been trafficked in. They come in. Some of them get smuggled in, you know, but once they get here, they get trafficked, either through labor trafficking or sex trafficking. And now, all of a sudden, I'm working with the U.S. Attorney's Office. I'm working with the FBI. I'm working with, ICE. And we're plucking these people out of these terrible situations, and we're actually able to get them relief so that they can leave the life and become free. And isn't that why a lot of us want to be lawyers, right? Is we want to be able to help the people escape situations like that. I actually have a case where I was successful. The client had gone to 3 lawyers. 3 lawyers said they couldn't help him. I took a look at it, and sometimes when you're doing pro bono work, what you want to do is you want to, if you know what the right result is, you fight to get the right result. And we were able to get her a Atty Visa, which is for trafficking victims. She's been free for 5 years, and she's graduating from college. And she actually wrote my parents a thank you note just because she's graduating this May. She actually wrote my parents a thank you note thanking me for saving her life, she said. It wasn't me that saved her life, but we all have to have vision, right? So when you're working with these people and you think you have a landlord-tenant or you think you have a family situation, you might actually have a victim of crime. You might actually have a trafficking victim that you're working with and you don't even know it. One of the most important things we can do here today is to help you issue spot, right? Do I have an immigration issue? And if you do, don't ignore it. Figure out what your clients want, you know, because you need to be able to protect them. All right, so here I am doing immigration now, and I get the privilege of telling you about the visa categories that we have. Now, a lot of these categories are the non-immigrant categories, and you doing pro bono, you're probably not going to encounter any of these doing pro bono, because if Justin Bieber comes to you and says that he needs a visa, I'm pretty much guaranteed you can charge him as much as you want. But anyway, but we do have, I mean, it's amazing how many visas we have. The A is for ambassadors, visitors. Now, a lot of these visas, what Chai is talking about, if they're non-immigrant visas, you're not allowed to have what's called dual intent. There's very few visas, non-immigrant visas, that allow you to want to immigrate at the same time, right? So, and if you have someone that is on a visitor visa that you're working with and they're working, that they're probably violating the terms of their visa, which in turn makes them undocumented. So it violates the terms of the visa. The ones that you might encounter, however, if you're doing pro bono work, is going to be the K, which is for fiancés. We get a lot of people that are trafficked through the mail order brides, right? So if you're dealing with mail order brides, you need to take a real close look at that, see if there's any domestic violence, see if there's any fishy situation, because you might actually have an immigration benefit that's available for a K where you can cut out the U.S. citizen that's doing the abuse and help that person immigrate without their knowledge or cooperation. Another one that you might come in contact with is going to be the probably the T, which is for trafficking victims, the U, which is for victims of crime, and the VAWA, which is the law that was created. Now, VAWA is not non-immigrant, it's actually immigrant, even though it's on this list. And the reason why is because normally when someone wants to immigrate to the United States, they have to have a sponsor. So in a family situation, you usually have the qualifying relative is going to be a U.S. citizen or a permanent resident. And if the U.S. citizen or the permanent resident is abusive, they can use the immigration system as a weapon against the person. So Congress created the Violence Against Women Act to allow people to try to access the immigration system without their sponsor. So that's what that is. And the U visa was incredibly successful for victims of crime. How many of you have heard of the U visa and know what that is? Okay, so some of you, right? Well, the U visa was just an incredible, mind-blowing experience for us immigration lawyers, because in the past, like I said, if you want to immigrate to the United States, you have to have a sponsor. Well, with the U visa, in that context, you could have two people who were undocumented and have a domestic violence situation, and then the abused spouse, even though both parties are undocumented, there's no sponsor in the relationship. So all of a sudden now we've created this class of people who are two undocumented people because of the domestic violence. If they're willing to cooperate with law enforcement in the prosecution or investigation of that crime, all of a sudden this person is immigrating with no sponsor. And it's a non-immigrant visa valid for 3 years. They get work authorization, and after 3 years they can, it's actually 4 years, I'm sorry. And then after 3 years they can apply for permanent residency. And they expanded it so much, it covers like all the derivatives, so even if they had children overseas. So as you can imagine, the U visa is widely popular. And I would imagine those of you who are doing pro bono work, that is something that you definitely don't want to overlook. All right, so if you're representing an abused immigrant, you need to take a close look at the T, the U, and the VAWA laws. Okay, visa waiver program. That is the ESTA. So those of you who want to travel to, Italy or the UK, we have these treaty agreements that allow us to travel amongst these countries, 38 of them, I guess, that have something where you just kind of sign in online, and then you can go visit for 90 days, and then you come back. Those of you who have seen Under the Tuscan Sun, don't you love that movie? Diane Lane goes down to Italy, and she gets off the bus, and she's like, oh, I just want to stay and live here. In the U.S., we're going to deport your rear, You can't do that. So, you don't get to just get off the bus and stay when you're here on an ESTA. An ESTA is kind of a restricted thing. Yes, it's a privilege to be able to come here without applying for a visa, but you don't get access to immigration court most of the time. You can't change your status. You can't go from one to the other. However, if you marry a U.S. citizen when you come in on an ESTA, then of course you can. There is procedures where you can apply for your green card without having to return to your home country. So, but that gets sticky, and you're going to want to see an immigration lawyer if that's the case, or be one. Okay. So immigration is like a two-step process, because like I told you, you first have to apply for the visa. All right, so you gotta be qualified for the visa. So if you are applying for an O visa of extraordinary ability, you better be a person of extraordinary ability. That's just the visa. How many of you seen the movie The Terminal with Tom Hanks? He comes to the airport and he's got the visa, right? The Department of State issued him a visa to come to the U.S., but then somehow there's this uprising in his country, so the visa no longer makes him admissible to the United States. So what happens, he gets trapped in the airport, and he stays in the airport for however many days or months or whatever it was. So you have to think of it in two steps. The biggest mistake I made as a new practitioner was to just try to think of everything all at once. I didn't separate out the fact that, oh, I got to determine whether or not my client is eligible for the visa first. In other words, if you're filing for a VAWA, self-petition for a abused family member, what are the eligibility requirements for that visa? Well, the eligibility requirements are going to be that they are married to, they have a qualifying relationship, so they're married to a U.S. citizen or a permanent resident. They've resided together. They have experienced extreme cruelty or battery, and they're a person of good moral character. 5 minutes. Okay, so, but what I tried to do is I would try to think of, I was looking, so when you're doing your research and you're like, oh, I think that somebody is going to be eligible for a U, a T, or a VAWA, but then you have to not forget the second step. The second step is applying for the green card or consular processing. And that's your inadmissibility stuff that Chai was talking about, the undesirables, right? You have TB, or you have public charge issues. You have a criminal record. You have made a misrepresentation when you entered. You have previous immigration violations. All those things that make you inadmissible, you know, the guy at the gate who's like, oh, please admit me, and Uncle Sam's saying no because you're undesirable. Don't get confused with figuring out what the eligibility requirements are for the visa with whether or not your client is admissible, because clearly you can have a client who is eligible for the visa but not inadmissible. If you don't know the difference, then you don't know when the waiver is, and it's very difficult to look it up and to know what you're doing. That's what I would do the most. I would be like, oh, my client's inadmissible, but I was looking in the visa category. So that's kind of your two-step process. 1, are they eligible for the visa? 2, are they admissible to the United States? 2 separate inquiries. Yes.
So of the 12 million that are undocumented in the U.S., I'd say about half have approvals for the first step. Mm-hmm. It's just the second step that bars them from becoming a legal permanent resident. And oftentimes we get clients who come in and say, you know, I have this approval notice. I married a U.S. citizen. How come I can't get my green card? And that's when we have to explain to them about the inadmissibility issues. And there are some inadmissibility issues that are not waivable, and we have to tell them unless the law changes, you're kind of stuck.
Right. So comprehensive immigration reform is not just about amnesty. It's about fixing these very punitive parts of the law that make it impossible for people who have qualifying relationships that should be able to immigrate to be able to file for some waivers and ask for forgiveness if they qualify. All right, so path to legalization, we talked about family-based, having a qualifying relationship. Employment, that's where your employer is applying for the visa. They are the sponsor. They're the ones that pay for it. Refugee and asylee, the difference between a refugee and asylee. The refugee is someone who goes to like the UNHCR overseas and is determined to be a refugee when they're overseas and they enter as a refugee. An asylee is somebody who comes to the United States and then seeks to be classified as a refugee after they get here. And asylum is where you're going to be doing your cases that are people who are afraid to return, and it's very rewarding work. I encourage you, those of you who want to do pro bono, that's one area that you could do. You can sign up. Our court is in Memphis, and you can get on a list, on a pro bono list. You can sign up, and you can take a pro bono asylum case. And I encourage you all to do that. It'll change your life. All right, special legislation like the Cuban Adjustment Act or something like that. Diversity lottery. Hey, it wouldn't be America if you couldn't play the lottery for a green card. So, but, you know, let me just say, right, so we have people who win the lottery. You know, they had the show called The Green Card in L.A. They like sponsored the green card show. And then they were finding that they'd have people that would win the lottery, but they weren't admissible. So they'd win, but then they can't enter the U.S. because they're inadmissible. So they canceled the show. And then there's other highly specialized visas, religious workers, investors, individuals. Of course, it is America. You can buy your visa as well. All right. Special options are going to be, right now we've had a huge influx of unaccompanied minors. So they may be eligible for special immigrant juvenile status. Those of you who are practicing in juvenile court or have an unaccompanied minor, you might be dealing with in your juvenile court proceedings, working with DHS, DCS, whatever. Yeah, thank you. You want to find out what your clients need, right? That's your job. What are their interests, because if you're representing someone in a criminal proceeding, you want to know kind of where they are in the immigration process and what their goals are. Do they want a defense to deportation? Well, you might have to craft a plea so that they actually have a remedy in immigration court. So that's your job. You have to issue spot. If you're representing an immigrant, then you better pay attention to the immigration status and what their long-term goals are to immigrate to the U.S. Conditional resident waiver. This is, the United States created this so that people who are getting their green card but have been married for less than 2 years, they can only get a green card for 2 years, so USCIS can make sure they really did marry not for immigration but for love. So anyway, VAWA self-petitioning and cancellations in court, no time to do that. Use and tease, self-petitioning, blah, blah. Okay, so then immigration enforcement, this is a fact that has changed my worldview a little bit, is that ICE only has the resources to deport about 400 to 450,000 people per year, which means we have to have priorities because we have 12 million undocumented people. So when President Obama is giving the priorities and how he wants his administration to prioritize who they're going to deport because they only have the resources to deport 400,000 of them, that's what he's doing. We've been working with deferred action and prosecutorial discretion for 10 years. That is a long-standing principle. So what he did on November 20th was to try to set those priorities, because he didn't want the little grandmas and moms and dads deported. So we've been doing, because again, they only have resources about 400, 450. But the problem is all the agencies don't talk to each other. They just want to fill their beds in whatever geographic location they're at. So instead of everybody trying to work together, the president is trying to be able to have his agency work together for the same purpose. Otherwise, everybody's just filling beds, and whoever gets deported gets deported. It's just kind of a waste of resources. So anyway, I am done. I don't have time to go over deferred action for childhood arrivals, which is the prosecutorial discretion, deferred action for the Dreamers, the DREAM Act. Since Congress won't pass the DREAM Act, we have to do it in a backdoor sort of way. And then the November 20th DAPA, which is deferred action for parents of children who are U.S. citizens. That will not be available unless we win the court case in May. So anyway, there's been a stop. So does anybody have any questions? That's immigration, quickly. In 45 minutes. Any questions? No? I think we're done.
Okay.
So,
Thank you.
All right.